Now I may kindly request Honorable Justice Sanjiv Khanna, Judge, Supreme Court, for the address.
Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Ms. Justice Indu Malhotra, former Judge, Supreme Court of India and Member, Permanent Court of Arbitration, Dr. Heb Mekin Zeplak, Secretary General, Permanent Court of Arbitration, Ms. Enna Jobin Bayet, Secretary, UNCITRAL, Mr. R. Venkataramani, the Attorney General of India, Mr. Kapil Sibal, the President of the Supreme Court Bar Association, judges from Supreme Court and the High Courts, and distinguished guests, Namaste and good evening. Today, as we celebrate 125 years of the Permanent Court of Arbitration and 75 years of the Supreme Court of India, we are reminded of the foundational principles that guide these institutions, pursuit of accessible and impartial justice. Justice in primary sense means and requires existence of rules that provide the right to a fair and a just decision, a procedure that provides equal and a fair opportunity to win against your opponents. Adjudication is not an end by itself. Adjudication should not be equated with the rule of law. Object and purpose of adjudication and rule of law is to ensure a just and a fair outcome and decision through a procedure free from influence of extraneous elements and internal prejudices. While media and political leaders often talk about maintaining political world order, adjudicatory interdependence is seldom focused and deliberated upon. Judicial interdependence is an acknowledgement of the need for global collaboration or for resolution of trans-border disputes and issues. Just as disputes are natural to humans, so is their resolution. We should begin by the age-old tenets of judicial comity or amity. These are practices among different states or courts of different jurisdiction involving mutual recognition of legislative, executive, and judicial acts. It is a cooperation of various judicial systems around the world which will ensure uniform application of law to the best extent possible. One of the key features of judicial comity is establishment of alliances between different judicial systems to ensure higher efficiency of legal proceedings at the global level. The concept of justice is enriched by learning from experiences and innovations from judicial institutions across the globe. Let us look at the Indian example. Not too long ago, there were questions raised whether democracy and constitution will thrive in all societies. Indian colonial rulers justified their rules by highlighting the society's perceived fragmentation, arguing that democratic individualism was incompatible with such diverse society. India showed that the world that this is possible. To achieve this ideal, the Indian Supreme Court is bequeathed with wide and expansive jurisdiction by the Constitution. Today, this court handles the largest volume of cases in any apex court globally. In 1950, when it was first established, the court had sanction strength of 8 judges and pronounced 43 judgments in its first year. Today, the court has a strength of 34 judges and pronounces more than 1,000 judgments per year. This court does not sit as a full court. The court typically sits in smaller benches of 2 and 3 judges. Despite the need for consistency and certainty, this ensures diverse representation and acknowledges various perspectives within the judicial system. Nevertheless, there exists an harmony, coherence among the benches, contributing to the evolution of law and establishment of precedents. It makes the court widely accessible and prioritizes accessibility to common citizens of our country. This court has a rich history marked by groundbreaking decisions that resonate with the aspirations of the constitutional founders. In response to challenges to access to justice, The court has proactively developed innovative remedies even beyond the traditional constitutional role to ensure complete justice in individual cases. This is done by exercise of power under Article 142 of the Constitution. Sometimes personal grievances were hindered by limited resources available to citizens, restricting their access to court. To address this and also to address broader constitutional issues, the Supreme Court introduced public interest litigation, allowing any citizen or a social action group to approach the court on behalf of general public or marginalized sections of the society. Judicial review, far from being one-sided, has fostered a collaborative dialogue between the judiciary and the other wings of the government. For instance, the Supreme Court landmark decision in Visakhapatnam versus State of Rajasthan sparked a national conversation on sexual harassment, leading to an enactment of laws to protect women in workplaces. In India, our trial and appellate courts presided over 26 million cases in 2023. Adjudicatory performance is often tested on daunting challenge of case backlog. Every judicial system grapples with this challenge, which is not only delays justice, but also erodes public confidence in the justice and legal system. To tackle this problem, Indian judiciary has turned to innovative solutions, blending modern legal frameworks with traditional methods of dispute resolution from Indian villages. Among these, Lok Adalats of People's Court, which operate outside conventional courtrooms, focusing on informal reconciliatory dispute resolution, stand out as a remarkable innovation. The success of Lok Adalats is a testament to their effectiveness. In last 6 years alone, they have resolved about 130 million cases, underscoring the capacity to reduce the backlogs. During the coronavirus pandemic, when physical courts were largely inaccessible, introduction of e-Lok Adalats brought these forums online, resolving over 7 million cases. India's experience with Lok Adalats and community mediation offer valuable lessons for global community. Arbitration is a leading method for resolution of commercial and international disputes. In line with these global trends, India has enacted several reforms to position itself as an arbitration-friendly jurisdiction, resulting in notable improvements in contract enforcement and ease of doing business. In FY 2014-15, FDI inflow in India stood at 45.14 billion, which increased to 60.22 billion in 2016 and 17. In FY 2021 and 2022, the FDI inflows increased to 84.83 billion. At this juncture, I'd like to also take this opportunity to acknowledge our association with the UNCITRAL in its long and enduring development of law of arbitration. The 1996 Arbitration and Conciliation Act is modeled on the UNCITRAL model. Later amendments to this act have brought Indian arbitration regime in line with international parlance. We have adopted and accepted that institutional arbitration should be preferred over ad hoc arbitration. We have speeded up arbitration by prescribing time limits within which awards should be pronounced. We have standardized arbitration by including setting standards for appointment and eligibility of arbitrators. And lastly, we have expedited or speed up arbitration is now being accepted and is being implemented. If I have to look for the future of international dispute resolution, I must say conciliation has to become and brought into the forefront. I'll quote from Mahatma Gandhi what he had said about conciliation. Truly a person is indurate and acts cowardly when he resorts to the court of law. Surely a decision of a third party is not always right. We in our simplicity imagine that a stranger, by taking our money, gives us justice. Taking inspiration from these words, perhaps global community should consider less formal ADR methods like mediation conciliation, which are far more flexible, non-technical in dispute resolution. Namaste and thank you.